Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the best-selling new book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out. Okay folks, I'm doing a little bit something different today. About 6 weeks ago, I put on a suit and I combed my hair, which I know a lot of you always talk about in the comments. And I gave a presentation about NYSRPA versus Bruen and how it was a robust originalist decision from the U.S. Supreme Court and why it's relatively easy to apply. I did this at the 2023 Originalism Symposium at the University of Virginia Law School on behalf of the Federalist Society down there. I appeared with the moderator, Jacob Rainier, as well as another professor, Rob Leiter, who's a professor of law at George Mason University in Virginia, and a former law clerk to Justice Clarence Thomas. So it was a fun panel. I'm going to put a link to the entire presentation down below in the description of this video. But in the meantime, you can check out most of my presentation. I didn't put it all here, but the essential part of the presentation dealing with how to apply NYSRPA versus Bruen in Second Amendment controversies, which I talk about here. So check it out. And again, if you want to hear more, hit the button. Check out the link to the full panel discussion in the description below. And again, if you haven't subscribed to the Four Boxes Diner, please do so. And don't forget to check us out on Twitter at Four Boxes Diner.
Professor Mark W. Smith is a visiting fellow in pharmaceutical public policy and law in the Department of Pharmacology at the University of Oxford, presidential scholar and a senior fellow in law and public policy at the King's College, and a distinguished scholar and senior fellow of law and public policy at the Ave Maria School of Law. He is a constitutional attorney and host of the Four Boxes Diner YouTube channel, which provides scholarly and historical analyses of the Second Amendment. Professor Smith is also a New York Times bestselling author. He is a graduate of the NYU School of Law and the University of South Carolina, where he earned a BA in economics. Before becoming an academic, Professor Smith worked as a law clerk to a federal district court judge, was associated with Skadden Arps, was a partner at Kasowitz, Benson, Torres, and Friedman, and founded his own litigation boutique with offices at Rockefeller Plaza, Madison Avenue, and Times.
I'm going to approach this question about originalism and the Second Amendment a little bit more from a practical courtroom experience, because that's a little bit more consistent with my background. But I do want to make three general observations and then get into each. The first is that Bruen is an originalist case. The second thing is it's extremely important that the Second Amendment jurisprudence succeed in light of what's going on. And last but not least, I want to talk about how you actually apply what I consider to be a very easy approach to the Heller-Bruen methodology, which I don't think is particularly difficult. So my first point is that the Heller-Bruen decisions, and they do go together because really, although we're referring to all this as the Bruen methodology of text and history and tradition, the reality is it's not really the Bruen methodology. What it really is the Heller methodology that introduced and talked about the importance of text, history, and tradition for originalism and interpreting the Second Amendment. It's just that now we're talking about Bruen because it's the latest thing. And frankly, Bruen, because of what was really lower court misbehavior, if you will, the Bruen court had to really lay things out in a much more detailed way than it did in Heller, because they were speaking to a lot of the misconduct, if you will, that was going on in the 10 years between Heller and Bruen. So really, the Bruen methodology is really the Heller methodology, and the Heller methodology is absolutely originalist because it says you start with the text of the Second Amendment, and there is no more fundamental starting point for an originalist than to start with the product, the outcome of the process that gave rise to the ratification of the Constitution, including the 1791 Second Amendment and the rest of the Bill of Rights. So certainly Bruen's attempt to interpret the text of the Second Amendment and then giving the government an opportunity to present history, a traditional regulation we'll get to in a second, to kind of discuss more about the scope of the Second Amendment, is very much an originalist endeavor. Now, this is very important for my second point. The discussion of originalism has been going on for many decades at this point, going back to really the founding of the Federalist Society, if you will. Now, let's talk about the actual methodology that Heller and Bruen together, you have to interpret them together, set forth. And I actually think it's a very straightforward process. the Supreme Court starts off and says, you start with the plain text of the Second Amendment. I don't think there's a lot of ambiguity there. The Supreme Court certainly doesn't seem to suggest there is, because if you look at Heller, it literally defined every term in the Second Amendment. It defines the people as essentially all Americans. It defines the right to keep as the right to have, to possess, the right to bear, the right to carry guns or carry weapons outside the home for the purposes of self-defense. So it seems to me that if you look at the text of the Second Amendment as interpreted by the Supreme Court, the definitions are all there and they're founded in history. For example, the Supreme Court in Heller quotes and cites to things like Samuel Johnson's famous dictionary that was in use at the time of the founding. So then you have the text of the Second Amendment is clear as I see it. Then, of course, you have the other aspect of the text, which are those things that come into play by necessary implication. That is, although the text of the Second Amendment doesn't refer to ammunition, although the text of the Second Amendment doesn't refer to magazines, although the text of the Second Amendment does not specifically refer to training or any of these things, courts have said that these are, necessarily implicated in the context of the Second Amendment, no different than, for example, the right to meet with a client in confidence or privately in a prison is implicitly part of the right to counsel under the Sixth Amendment. Or, for example, the right to have ink, the right to have access to an internet, the right to have access to paper, and the right to be able to buy a printing press are all necessarily implicated by the right of free speech and the right of free press under the First Amendment. So you have the plain text as defined by the Supreme Court, and then you have other things that are necessarily implicated, which I've just discussed, which is a traditional way you interpret the Bill of Rights, among other aspects of the Constitution. So once you get to that, now we get to the rub of the question of this panel, which is what exactly now is the role of history and what is the role of tradition? Well, the answer before Bruen, as I used to argue it or discuss it, was the following. And then I'll talk about where we are today in light of the Bruen decision. The way I used to interpret history and tradition was, you look at the history of the Second Amendment, and then that was basically at the time of the founding. And tradition was what happened in the 19th century, which can serve as what I would call a confirmatory analytic, which means that if you have 19th century history that corroborates the 1791 understanding, that can be considered and that is relevant. But if you have 19th century history that is inconsistent with the 1791 understanding or the 1791 text of the Second Amendment, then you have to discount it, which most recently, by the way, we saw by the U.S. Supreme Court in 2020 in a slightly different context involving the First Amendment. We saw in 2020 the Supreme Court decided the Espinoza versus Montana Department of Revenue decision. And in that case, that was a situation that interpreted the First Amendment's right to free exercise of religion. And in that case out of Montana, there was a specific state statute that barred, I won't get into the specific details of the case. The bottom line is that under the Montana laws, religious private schools were treated less well than non-religious private schools. And the religious schools in Montana sued under the First Amendment's exercise clause, saying that we are being discriminated against and this violates the First Amendment. And if you look very carefully at the decision of Espinoza, this is very telling. Even though it's in the First Amendment context, it really speaks to, I think, where this court is at mentally, because the decision in Espinoza was written by Chief Justice John Roberts. And what Chief Justice John Roberts said is, you look basically at the time of the founding to understand the scope of the First Amendment. And then Montana, by the way, brought forth 30, I repeat, 30, that's 30 different state laws that were enacted in the late 19th century that said that you basically could discriminate and by not using public money to go to religious schools. And in Espinoza, the Supreme Court specifically said that the fact that Montana came forth with 30 late 19th century state laws that in their view discriminated against Catholics, that's what the impetus was, so the Supreme Court said, that was not a basis for overriding the original meaning of the 1791 First Amendment. So when it comes to the Second Amendment, I think metaphorically or analogously, it's the same concept. The late 19th century evidence that contradicts the text of the Second Amendment or understanding the Second Amendment in 1791 cannot override or contradict or undercut that 1791 right. At most, late 19th century laws can confirm the 1791 understanding. It's a one-way ratchet. But let me continue. Now, you have the plain text, and once the modern-day gun control law is implicated by the plain text, what happens? Well, there's two things that happen. The burden shifts to the government. In the same way that when you walk into a criminal court, you are presumed innocent. In the context of the Second Amendment, the Supreme Court has said that if a modern-day gun control law is implicated by the Second Amendment or whatnot, the Second Amendment is triggered by a modern-day gun control law because it affects the right to keep and bear arms, the burden immediately shifts to the government to justify it. And the law is presumptively, I repeat, presumptively unconstitutional. No different than when you go into a criminal court, you are presumed innocent. So the burden becomes entirely upon the government. And this is extremely important. That's the procedural posture of what happens when the Second Amendment is triggered by a modern-day gun control. Now, the second part, the substantive part, is extremely important when you combine it with the procedural. Because once the burden shifts to the government to demonstrate that a modern-day gun control law is constitutional, the burden is entirely on the government. And if the government cannot demonstrate that modern-day gun control law is consistent with the Second Amendment, they lose. It doesn't matter why they can't meet their burden. If they cannot meet their burden for any reason, they lose. I draw the analogy to a criminal case. If you go into a criminal court, you've been accused of a crime, the burden shifts to the government. They have the burden to come forth with beyond a reasonable doubt evidence that you've committed a crime. It doesn't matter why the government cannot prove their case. If they have bad lawyers, it doesn't matter, they lose. If they can't find the murder weapon, it doesn't matter, they lose. If they lose a witness, if a witness moves out of town and they can't prove their case, it doesn't matter, the government loses. I think the same concept applies here because the Supreme Court made it very clear in Miller and Bruen, if the government cannot meet its burden, the government loses. Now, this is particularly true if you look at footnote 11 of Bruen, which talks about how to interpret the Sir John Knight's case. There was a long discussion of a case that the anti-gun community was trying to use to cut down on our right to keep and bear arms. It was the Sir John Knight's case from jolly old England. I won't bore you with the details, but the bottom line is, countless volumes of books and articles were spilled on what was the meaning of the Sir John Knight's case. Did it mean that, that government could restrict the right to carry weapons, or did it mean that you could only restrict the use of weapons to go about terrorizing the countryside or terrorizing the people? The pro-gun view was the Sir John Knight's case stood for the proposition that you could not misuse firearms to terrorize people. The anti-gun position on Sir John Knight was it proves that they can regulate just general carriage of firearms all across, the country or in public. The Supreme Court in footnote 11, after distinguishing Sir John Knight's can find it unpersuasive for the anti-gun side, they did go on to say at the bottom of footnote 11 in Bruen the following. They says, to the extent there is any ambiguity about how to interpret the Sir John Knight's case, we, the Supreme Court, opt to presume and defer to the interpretation of the Sir John Knight's case most consistent with the Second Amendment's command. To me, I read footnote 11 of Bruen very specifically that says that if the government cannot come forth with a clear proof, and we're going to get to what that proof is in a second, then they lose. And that's what footnote 11 says. When in doubt, freedom prevails, the fundamental right to keep and bear arms prevails, and the government loses. So what exactly does the government have to prove, and how does this play a role with history and with tradition? And I think it's actually quite simple. The way to understand it is once the plain text is implicated, the burden shifts to the government has to do the following. The government bears the burden to review history. The process that they have to undertake is a historical survey, a historical review. What they're not allowed to do, and this reason why this is so important, as Professor Leiter articulately pointed out, was that the destruction and the end of tiers of scrutiny, which is a euphemism, by the way, for allowing judges to balance away your rights in the name of some government interest. So tiers of scrutiny is clearly, kicked out the door. It was, I think it was kicked out the door in Heller, but was certainly kicked out the door now in Bruen, and in its replace was a historical review. Now, so we know that instead of tiers of scrutiny, the government has to come forth and do a historical review. That is the methodology, the process they must use. Now, with that said, what exactly is the government looking for when they conduct that historical review, which they're obligated to do to the extent the Second Amendment language is triggered by a modern-day gun control law? The answer is found in the holding of Bruen itself, specifically that the government has to survey history and find, if they can, a tradition of regulating firearms in the same manner, the how and the why, if you will, of modern day gun control law. This is the holding from Bruen. You don't have to trust me. You can trust the holding of Bruen. This is what it said, quote, in keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects the conduct. To justify its regulation, this is the key part, and then I'll wrap up. The government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. And the only point I will make to that is when you're talking about firearm regulation, you're actually talking about actual enacted laws that were enforceable by law and not some sort of theoretical concept that some of the anti-gunners want to talk about. They have to come forth with a tradition of actual laws. And the one example I would say, and then I'll wrap up, that I think prove that the government can show is a longstanding tradition of law that regulates firearms is the misuse of firearms, for example, to commit murder or robbery, to the extent, you know, you're not allowed, there's a law that bans you from using a gun today to commit a robbery or a murder. Today, you go back to the time of the founding, that law, meaning you could not misuse firearms, has existed since not just the founding, but even before the founding. That would be a very easy example for the government to find that longstanding tradition of firearms regulation is constitutional, even though it's not specifically in the text of the Second Amendment. And look forward to continue the conversation and answering any questions. All right, I hope you enjoyed that snippet of my presentation at the University of Virginia's Federalist Society at the University of Virginia Law School about originalism and NYSRPA versus Bruen and the Second Amendment. And again, don't forget to subscribe to the Four Boxes Diner. If you haven't done so already, please do so. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.